A very good morning to everyone. Today we'll be discussing in reference Berubari Union, a case of 1960 Supreme Court. At the time of partition of India and Pakistan, the India Independence Act 1947 provided that the task of demarcation of boundaries was to be assigned to a commission. And the commission consisted of 5 members, 4 judges, and Sir Cyril Radcliffe. Thus, the award came to be known as the Radcliffe Award. The Radcliffe Award distributed thanas between India and Pakistan, and the boundaries of such thanas were going to be the ultimate boundary between India and Pakistan. Of note, the award came into effect 3 days before the Independence Act was enforced. Thus, the boundaries were to be decided as per the award and not as per the India Independence Act, wherein it provided the territories that are go to East Bengal. Now this is a map wherein you could see the areas, the enclaves between India and Pakistan, and Jalpaiguri district is where Berubari Union was located, and Berubari Union can be seen in the top left corner. So, because the Berubari Union was a thana in Jalpaiguri district of West Bengal, and Radcliffe awarded it to India, but unfortunately it was not mentioned in the written boundary demarcation provided in Annexure A to the award. Thus, Pakistan claimed Berubari, citing the reason that Berubari falls in the map of Pakistan. Fortunately, after this, the Constitution of India was enforced, and the provision regarding the boundary, that is the states or territories of India, was enforced on 26th November 1949 itself. And in this, Schedule 1 provided what constitutes Bengal, and Bengal was understood to constitute Berubari Union as well. So thus, India governed Berubari Union, considering it to be its legitimate territory. Despite this, the dispute continued till Nehru-Noon Agreement was signed between India and Pakistan in 1958. And in the agreement, the territory of Berubari Union was divided and distributed equally between India and Pakistan. After much criticism, the President of India referred the matter to the Supreme Court, and that's why it is known as in reference Berubari Union. The Supreme Court mentioned that there was no trace in the agreement, that is Nehru-Noon Agreement, of any attempt to interpret the award or to determine what the award really meant. India was prepared to give half of the area of Berubari Union to Pakistan to ensure friendly relations and remove causes of tension between them. It also went on to say that a sovereign state can acquire foreign territory, and this is the attribute of sovereignty, and similarly a foreign state can cede territory, and that's also an attribute of sovereignty. Yet, secession of national territory in law amounts to transfer of sovereignty over the said territory by the owner state in favor of another state, and so this will have to be done in pursuance with international law, that is through a treaty. At the same time, the treaty-making power of the owner state would have to be exercised in the manner that is contemplated by the Constitution and subject to the limitations therein. What it means? It means that whenever the treaty is made, whether the treaty can be implemented by ordinary legislation or by constitutional amendment will naturally depend on the provisions of the Constitution itself. Now, Article 3 of the Constitution of India mentions that the Parliament may by law form a new state, increase, diminish, or alter the boundaries of any state. Article 3 Clause C is of much attention over here, wherein it states that the Parliament may by law diminish the area of any state. Now, would this diminishing include diminish the area of any state to give away to a foreign state? The court answered that in negative. It said that under Article 3 Clause C, the area would have to be adjusted or diminished in such a manner that the area continues to be a part of the territory of India and not given to a foreign state. Thus, to implement the agreement, the court said, the Parliament would require to make a constitutional amendment under Article 368. And it can do two things. Either it can amend Article 3 to allow for secession of territory foreign state, or it could implement this agreement by a constitutional amendment. Thus, the Ninth Constitutional Amendment Act 1960 was enacted to give effect to the agreement, but it could not be enforced. Subsequently, the land boundary agreement was signed on 16th May 1974 between Indira Gandhi and Sheikh Mujibur Rahman, which provided for the exchange of enclaves and surrender of adverse possessions. Under the agreement of 1974, India retained Berubari Union number 12, while Pakistan retained the Dahargam enclave, with India providing access to it by giving a 178 by 85 meter corridor called the Teen Bigha corridor. And this is how the entrance to the Teen Bigha corridor looks like. The question came before the court, would the implementation of this agreement be allowed? As in, could Teen Bigha corridor be leased to Bangladesh without a constitutional amendment or without legislation by the parliament? The court answered that in affirmative. It said, in the case of Union of India versus Sukumar Sen Gupta, the court said in order to effect a lease, there would be no constitutional amendment required. It could be done by an executive action. At the same time, the Supreme Court has clarified in 1969 in the case of Magan Bhai Ishwar Bhai Patel versus Union of India that examined the implementation of the International Tribunal Award regarding areas in Run of Kutch, and the court ruled that the settlement of international boundary dispute between India and Pakistan does not require constitutional amendment. Rather, it can be done by an executive action alone, and only if it does not involve secession of territory. So whenever there is secession of territory, it would require constitutional amendment, and whenever there is adjustment or a boundary dispute being resolved by international tribunal, then it would not be, and it is not secession of territory. Now you will be confused, how would it not be secession of territory? Sometimes the states themselves know that they cannot de jure exercise sovereignty over a certain area, and when those areas are resolved through a tribunal or arbitral award, then it does not amount to secession of territory, as was the case in Magan Bhai Ishwar Bhai Patel. And with this, you will now understand that why the 100th Constitutional Amendment Act was enacted in 2015, which allowed for exchange of enclaves between India and Pakistan, because to implement that treaty, you require to have a constitutional amendment, because there was a transfer of 111 Indian enclaves to Bangladesh in return of 51 enclaves to India. Thus, Berubari Union, the seeds it sowed, clarifying the limits on the parliament's power to secede a territory, was somewhat, continuing to have its legacy even now. A very much thank you for being with the presentation.